Welcome to the third video of this module. We will now build further on the previous video, which discussed the main principles of investment arbitration. In this video, we will look more in detail at the types of claims that can be submitted to investment arbitration. Investment arbitration, as a term, incorporates in reality two types of arbitration. The term itself simply implies that the arbitration relates to an investment and that there is a dispute over an investment. However, the legal basis upon which the investment arbitration is founded has important consequences on which types of claims investors can bring and which arbitral tribunal has competence to hear such claims. In general terms, the arbitration can be based on an investment contract or on an investment treaty. A third but less used method is arbitration based on a national legislation that provides access to arbitration. This has also been discussed in the first video, in which I explained that originally investment arbitration was included in contracts. Investment treaties are a phenomenon that emerged only in the end of the 60s, early 70s. At this moment, if we rely on the statistics of the ICSID, around 74% of ICSID arbitrations are based on treaty, 17% on an investment contract, and 9% on national legislation. In practice, foreign investors, when investing in a foreign state, will sign an investment contract with the host state or one of its agencies. This is often the case in the event of an oil or mining concession, but keep in mind that there is not always a contract. One can well imagine situations where the investment is acquired abroad without any contract being signed with the host state. In the event of the coexistence of an investment contract and a treaty, a distinction should be made between contract claims and treaty claims. Tribunals have over the past years held that tribunals established under a treaty have competence to hear claims based on breaches of the treaty by the host state. Conversely, claims that are based on breaches of the contract by the host state or one of its subdivisions or agencies should be brought before the dispute settlement forum provided for in the contract. The contract dispute settlement forum can be arbitration, but one also frequently finds domestic courts or tribunals. However, some treaties also provide for the possibility of a treaty-based tribunal to hear contract claims. One should always carefully look at how the arbitration clause in the treaty is formulated. The distinction, as said, is important. If an arbitral tribunal based on an arbitration clause in a contract has competence, the law it will apply to the dispute will be the law provided for in the contract, most often the domestic law of the host state. International law then only plays a marginal role. It will only be used and applied to supplement or correct the domestic law. On the other hand, if an arbitral tribunal is based on an investment treaty, its task is to appraise whether there has been a breach of the treaty by the host state. The tribunal then primarily applies public international law, the treaty, customary international law, so long as the treaty has not deviated from custom, and general principles of public international law. However, even then, domestic law may be relevant. For instance, to determine the existence and contours of investment-related rights of the foreign investors, such as the existence and validity of an oil concession. The main grounds invoked in case of treaty claims are breaches of the fair and equitable treatment standard and protection against arbitrary and discriminatory treatment. Such standards of treatment are present in the vast majority of investment treaties. Historically, investment disputes related to the expropriation of the foreigner's investment and the resulting obligation to pay a compensation. Nowadays, direct and outright expropriations have become less frequent. Indirect expropriations, on the other hand, are often a ground invoked by foreign investors. Indirect expropriations are in essence measures taken by the host state which have an effect similar to a direct expropriation. Such acts may amount to a breach of an investment treaty, provided that the act in question was not taken for the protection of the public interest. Indirect expropriations are often invoked by foreign investors in treaty claims, yet it is often difficult for a foreign investor to successfully argue their case. In the next video of this module, you will learn about the ICSID and more specifically the special features of this arbitration institution.